Good morning, Mr. Chairman, members of the board, and all those in watching proceedings in the room and on Charm TV. The April 24th proceedings of the Board of Liquor License Commissioners for Baltimore City will now begin. Please take this opportunity to turn off or mute all of your electronics. Please don't be that person whose phone goes off in the middle of the hearing. The board is now in session. Just a couple of preliminary matters. If you're here for a particular case, if you have not already done so, please check the docket on the door. That is docket that is taped on the door as you entered the room to make sure your case is scheduled for the day. Case number 6 on the docket has been postponed. Grace Pilot Jacobson Farrows Marine LLC, trading as Oasis Marina at Lighthouse Point, 2711 Boston Street. It is an application to transfer ownership with continuation of outdoor table service. We have a few esteemed guests here with us today. Commissioner Templeton's children are here for Bring Your Children to Work. We have Granville the Fourth and Grant. And has Tristan arrived yet? I don't think so.
She's coming.
She's coming. Yeah. Yep. Thank you for joining us.
Good morning, guys.
It should be an interesting day for you all to see what your dad does. Absolutely. And then finally, starting on May 8th, this is extremely exciting news that we're glad to share. Starting at the next hearing date, which is May 8th, liquor board hearings will be held in the board's new hearing room, which is, it's been a long time coming, and that is located at 200 St. Paul Place, Suite 2300. We have really been working hard to make the shift, but needed to make sure that we were still able to stream, that we would have appropriate security, and in that regard, we really want to say a huge thank you to BSIT for helping to outfit the hearing room with the technology we need, and for the continued partnership with the Sheriff's Office, who will be providing security. Okay, we're ready to go into the docket, sir. First case, 180-day hardship extension. Tanae Demisi and Fikramariam Worku Janu Ethiopian Restaurant and Lounge, LLC, trading as Jano Ethiopia, 34 South Utah Street, Class B, beer, wine, and liquor license, request for a hardship extension under the provisions of the Alcoholic and Beverages Cannabis Article, Section 12-2202. Please come forward.
Good morning, Your Honor. Good morning, Commissioner. Stephen W. Fogelman on behalf of the applicant, who you know, Mr. Jano, suffered a big fire right around the end of the Orioles regular season last year, and he needs the 180 days. His 180 days ran on March 21st, so we're asking for 180 days after that date.
Is he going to be able to reopen?
He thinks so. At this point, it is truly a race against time.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you, Mr. Fogelman. On the basis then of your written request to the board dated March 14 of this year and your proffer this morning, I vote to approve a 180-day hardship extension for this Class B beer, wine, and liquor license.
Yes, based on material, testimony, and letter from the attorney, I also vote to approve the request for a hardship extension of 180 days.
Based on your March 14th letter and your proffer made today, I also vote to approve this 180-day hardship extension of this Class B beer, wine, and liquor license.
Any
No
exhibits?
no exhibits for the record.
All right, thank you.
Thank you. The next one.
Tanya M. Austin and Adrian M. Savage, new 2 O'Clock Club, Inc., trading as 2 O'Clock Club, 414 through 416 East Baltimore Street, Class BD7 beer, wine, and liquor license, and Class AE adult entertainment license. Request for a hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-2202. Please come forward.
Thank you. Good morning. Stephen W. Fogelman on behalf of the licensee, Tanya Austin. It's my understanding that she filed a request, a hardship extension request, on January 17th, 2025, indicating that the premises had been closed since September 15th. The 180-day closure, 180 days from that closure was March 19th. So we are asking for 180 days from March 19th, which would be September 15th, 2025.
And she's indicating that she's going to keep it closed until she can sell the license, is that right?
That's what the correspondence indicates. I've got 2 death certificates here. I don't know if that's necessary, but indeed.
I'll accept her proffer.
She
then.
lost,
Had
some family.
Her
there.
mother and her grandmother, apparently. Commissioners have any questions?
No question.
No questions.
All right, thank you. Once again, on the basis of the applicant's written request of January 17, 2025, and council's proffer this morning, I vote to approve a 180-day hardship extension for this BG7 beer, wine, and liquor license and Class AE adult entertainment license.
Yes, based on materials, testimony, and letter from the owner, I also vote to approve the request for a hardship extension of 180 days.
Based on Ms. Austin's January 17th, 2025 letter and proffer made by council today, also vote to approve this 180-day hardship extension of this Class BD7 beer, wine, and liquor license and Class AE adult entertainment license.
No exhibits for the record.
Thank you all.
Richard H. Anderson and Soon Hwa Tark, STCL Inc., trading as Bunny's Liquors, 2217 through 19 North Fulton Avenue. Class A beer, wine, and liquor license request for a hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-2202. Please come forward.
Who's Mr. and Ms. Tark? That's you, okay. And is one of you Mr. Richard Anderson?
No,
No,
not yours.
you're just
How's it?
with them? They're your family?
No,
Yeah.
no, I'm helping
Translate.
interpret for them.
Okay.
Yeah,
Would you all
I'm
raise your
your
right
son.
hands, please?
Mr. Chair, I need to actually
Yeah.
swear him in separately as an interpreter.
That's fine.
first.
Go ahead.
For you specifically, do you swear and affirm under the penalty of perjury that you will interpret to the best of your ability and translate into English and what was the other language?
Korean.
Korean, to the board?
Yes.
Okay, thank you. And that would be for the witnesses. And separately, do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
저기 거짓말 안 한다고
Okay,
그냥
yeah,
물어본 거예요.
yes.
And can you state your name for the record, please?
My name is Daniel Lee. I'm her son.
Okay,
Is it L-E or L-I?
L-E-E.
L-E.
okay.
Two
Uh,
E's.
So, Ms. Tark
Yes.
sent a letter to the board on March 31, 2025, indicating that there was a fire on March 7th?
Yes,
Is that
that's
correct?
correct.
And I guess you're closed, is that correct?
Yeah, we're closed until we can either move, sell the license, or rebuild. But we're trying to set up shop again at
Okay.
the same location. That's what we're trying to do.
So requesting 180 days, is that
Yeah.
correct?
Yes, sir.
Okay. Commissioners have any questions?
No question.
No questions.
All right, thank you. On the basis then of Ms. Tark's written request to the board of March 31, 2025, and your representations this morning about the fire and your intentions, I vote to approve a 180-day hardship extension for this Class A beer, wine, and liquor license.
Yes, based on material, testimony, and letter from the licensee, I also vote to approve the request for hardship extension of 180 days.
Based on Ms. Tark's March 31st, 2025 letter and any proffer made today, I also vote to approve this 180-day hardship extension of this Class A beer, wine, and liquor license.
Exhibit?
No exhibits for the record.
All right, thank you, folks. Good luck.
Okay, thank you.
Thank you.
Nuttawood, Metawapari, and Javelak Metawapari, Royal Thai LLC, trading as Thai Restaurant, 3100 Greenmount Avenue, Class BD7, beer, wine, and liquor license request for a transfer hardship extension under the provisions of the Alcoholic
They're
Beverages.
excused. If they don't need to stay if they don't want.
You can leave.
You may get leave. Thank you.
Not the boys.
Under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B, please come forward.
Good morning, Stephen W. Fogelman on behalf of the Metawipparies, and they run a restaurant that's been quite popular at 3316 Greenmount Avenue. The transfer was supported by Councilwoman Ramos and the community. They need another 90 days to try. The construction has delayed them. They need at least extra time. They may even need to have to file an amended application due to the construction delays.
Okay.
But
And it's going to be a renovation? that's taking
yes,
place?
it's a brand new, or yeah, it's definitely a big reno. and it's going to be lovely, but construction is just, it's unpredictable.
Okay, well, the weather's good now, at least for
Indeed.
today, so let's hope. that
Exactly.
benefits.
Thank
Okay.
you.
Commissioners have any questions?
No questions.
No questions.
All right, thank you, Mr. Fogelman. On the basis of your written request of March 14th and your proffer this morning, I vote to approve a 90-day transfer hardship extension for this BD7 beer, wine, and liquor license.
Yes, based on materials, testimony, and letter from the attorney, I also vote to approve request for transfer hardship extension of 90 days.
Based on your March 14th letter and your proffer made today, I also vote to approve this request for a 90-day transfer hardship extension of this Class BD7 beer, wine, and liquor license.
Ms. Russell?
No exhibits for the record.
Thank you.
You've got the last one then as well.
Got two, yeah.
Christopher Mack Chen, Peter Zhang Baltimore LLC, trading as Peter Chang, 1923 Ashland Avenue. Class B beer, wine, and liquor license request for a transfer hardship extension under the provisions of the Alcoholic Beverages and Cannabis Article, Section 12-1705B. Please come forward.
Thank you. Stephen W. Fogelman on behalf of the applicant at 1923 Ashland Avenue. This is just quite frankly, a in-corporate transfer of a different corporate officer. They still need to do inspections, and they're a little behind in that, so they're asking for the additional time.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis of your written request of March 17, 2025, your proffer this morning, I vote to approve a 90-day transfer hardship extension for this Class B beer, wine, and liquor license.
Yes, based on material, letter, and testimony, I also vote to approve the request for transfer hardship extension of 90 days.
Based on your March 17th letter and your proffer made today, I also vote to approve this 90-day transfer hardship extension of this Class B beer, wine, and liquor license.
Thank
Ms.
you.
Russell?
No exhibits for the record.
All right, thank you.
Kim Warren Thompson, Gaberhood Inc., trading as Leon's, 870 Park Avenue, Class BD7 beer, wine, and liquor license. Application to transfer ownership with continuation of live entertainment. Please come forward.
Good afternoon. Stephen W. Fogelman here on behalf of the applicant, Kim Warren Thompson, who's present.
Still morning, Mr. Fogelman.
Oh, wow. That's a force of habit.
That's
Hey,
okay.
you got to forgive me. I'm just a little excited because this is the penultimate hearing of the liquor board at City Hall. Only
That's true.
fitting that Mr. Previs should send you out with the last. Save the best for last.
And Leon's has been around for a long time. Okay, so what's going on, Mr. Fogelman?
And we've been around for a long time with this application. This is actually the third time we filed a transfer application here. The first time there was a tax hold. The second time there was issues with the health department and kitchen equipment that wasn't being used. Everything's been fixed up. Third time's a charm. And Mr. Thompson has been before you twice already. He's retired and self-employed. He's ready to, and he's already works with the bar, and he is ready to take the reins.
And you're alcohol certified?
He is.
Okay, and everybody who handles alcohol will be?
Indeed. Thank you.
Okay, and familiar with our rules and regulations?
Yes.
Okay. Commissioners have any questions?
No questions.
No questions.
All right, thank you. On the basis of the materials contained in this refiled application, as well as the proffer from council, I vote to approve the transfer of ownership of this BG7 beer, wine, and liquor license with continued live entertainment.
Yes, based on material testimony provided today, I also vote to approve the application to transfer ownership with continuation of live entertainment.
Based on the materials in this refiled application and the proffer made by council, I also vote to approve this application to transfer ownership of this Class BD7 beer, wine, and liquor license with a continuation of live entertainment.
Ms. Russell?
No exhibits for the record.
All right, thank you. Good luck, sir.
Thank you. Thank you all. See you at St. Paul Place.
Yes, we hope. Thanks. Mr. Page, whenever you're ready.
Thank you, Mr. Chairman. Good morning. Calling the case of Mr. Wayne Lang, 4001 Falls Road. Chief, the applicants and the attorney, please, for the applicant.
Thank you.
Yes.
Where are the instruments?
Wayne Lane, Parker Golf LLC, trade name pending, 4001 Falls Road, rear unit. This is a Class B beer, wine, and liquor license. An application for a new Class B beer, wine, and liquor restaurant license under provisions of Alcoholic Beverages Article and Cannabis Article 12-1603, small c, number 1, small I, requiring $200,000 in capital investment in restaurant fixtures and facilities and seating capacity for a minimum of 75, requesting outdoor table service and off-premises catering. Mr. Chairman.
Counsel, will you identify yourselves for the record, please?
Good morning, Mr. Chairman. Peter Previs, along with my son Harry Previs for Take Your Child to Work Day, on behalf of Mr. Wayne Lang, who is to my immediate right.
Good morning. Counsel?
Hi, my name is Denise Coe for Community Law Center for Hamden Community Council.
Okay. This case comes before us with a challenge under Section 12-1508 of our statute and our Rule 2.06. So in the event that we're going to get to testimony, let me ask all those who are here to raise your right hands and be sworn.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, so why don't you folks sit down for a minute because the lawyers have a bit of business to take care of. Mr. Previs, you have a motion before us.
Yes, Mr. Chairman. I just wanted to, as I understand it, the parties had negotiated well into the night, but at this point, we don't have a resolution.
Well, actually, Mr. Wayne Lang was not present. It was just a friend of his that had come.
Okay. But there were...
Were you close to a resolution?
There's not that many issues, but the closing time is like huge, so it's like, that's
All right, well,
where it is.
we can go, all right, well, let's hear on your motion then.
Okay, so, on behalf of the applicant, I had filed a motion to dismiss, which I had known this statute to colloquially be called the 51% rule. Other people call it the 50% rule, but I think...
I call it the more than 50%.
More than 50%
You've got to be
rule.
over the 50-yard line.
Correct, so, but it's under the case of Karen Patton versus Board of Liquor License Commissioner for Baltimore City, they also referred it to it as the 51% rule. In any event, the basis for challenging the statutes that comprise the more than 50% rule are that by setting into place such a mechanism, the legislature is basically sidestepping the liquor board and allowing the residents within 200 feet who are in fact non-governmental officials to determine or veto whether or not a license is allowed to go into a place. So the preliminary issue that I had posed in my memorandum was that, does this board have authority to determine constitutional issues? And under the cases of Insurance Commissioner of Maryland versus Equitable Life Assurance Society of Maryland and Prince George's County versus Ray's Used Cars, they absolutely do, and in fact are obligated to determine constitutional issues. Ms. Coe, in her reply, indicates that where a challenge is made, a facial challenge is made to a statute, that this board does not have authority. I read it differently. I read that there are 5 exceptions that would allow you to file an action for declaratory and injunctive relief in the circuit court and sidestep the liquor board. But those exceptions don't require that you not go present the issue before the board in its first instance.
Do you think you have to exhaust your remedies?
And you would have to exhaust your remedies. And if you didn't exhaust your remedies, then on appeal, the court would indicate you didn't raise it below and you waived it. So I believe the board is obligated to decide the issue.
Whether we decide or not, I think you're meeting your exhaustion requirement by filing your motion and arguing it, but we'll see, you know.
Right.
Yeah.
So, okay, so substantively, there were a trilogy of U.S. Supreme Court cases that go back around 100 years, and each of the three made a distinction that if a statute delegates authority to allow or disallow some conduct, or approve or disapprove some conduct, that would deny due process because you are delegating governmental authority to private citizens. Now, there's a distinction that's been spelled out in the case law since that trilogy of cases, and it's easy for us to understand based on our liquor law rules. So you have a statute that says that no liquor licensed establishment can be within 300 feet of a religious institution or a school. And if that statute goes on to say, and that statute is designed as a 100% prohibition. But if the statute goes on to say, but if the affected religious institution or school indicates that it is not opposed to the liquor license, that is not a prohibition, a non-lawful prohibition. That is, in fact, a lawful waiver by that private institution. So those statutes are okay. But if you have a statute that authorizes anyone to potentially apply for a liquor license anywhere in Baltimore City, and that applicant would have a burden of proof to show that there was a public need and accommodation and that it would not unduly disturb the peace and what have you, then the Connecticut case that I cited indicates that in that circumstance, you are basically allowing a certain conduct, but you're giving private individuals a right to veto something that's otherwise allowed. And that is the distinction that makes that unconstitutional as a denial of due process.
It reminds me, your brother John would appreciate this. When we were in law school more than 50 years ago, there was a case called Schechter Poultry, and one of my favorite lines was "Delegation run riot." And I suspect that's somewhere where you're headed with this argument. But
Correct. So, well, I guess after the 30s and the changing of the courts, I think Schechter Poultry was one that
it had
didn't
something to do with
survive.
the Administrative Procedure Act. back
Yeah,
then.
I think when I learned it in law school, they called it the sick chickens case. I remember that. In any event, so the Connecticut case, I believe, is on all fours and is not constrained to some peculiar provision in the Connecticut Constitution or anything else. You've got the same thing. You have apparently some of these laws that arose in the states shortly after Prohibition, where they would allow neighbors within a certain amount of feet to protest, and if they all voted no, then no chance for a hearing before the board. And that's what we have here. And I strongly believe that that is unconstitutional. Ms. Coe argues that a liquor license is a privilege and not a right. I agree with that. It is a privilege and not a right. If you were to look at the case of Moose Lodge versus Irvis in 1972, you had a situation where an
This case was not in your brief, though.
It wasn't. I'm replying to what you said.
But she hasn't said it yet. You want to wait? Let her argue, and then I'll let you rebut.
I just briefly on this point, because I think that's where the distinction lies.
I haven't argued yet, so I object.
Okay.
Why don't you hold it for a second?
Okay.
Go ahead.
You got it.
Hi, Commissioners.
Hi.
So Mr. Previs, on behalf of the applicant, is bringing a facial challenge to 12-1508 today. It's on the state statute's constitutionality as a whole, and that is something that cannot be ruled on by a local liquor licensing board for lack of authority on a couple reasons that we cite in the brief. And the first one is that this kind of facial challenge is distinguished in both of the cases that Mr. Previs brings up, Inequitable Life and Rays, It's discussed that matters that require factual determinations at the agency level to determine how the law specifically is applied, that might be unconstitutional for those facts. It's distinguishable. And secondly, and more fundamentally, there just is no constitutional right to a liquor license, which is a privilege, and we can really get into that when we talk about the substance, but.
So is it your position, so he's arguing that he has an exhaustion problem and that he's got to bring it here, and that you're saying, I believe, if he needs to make a record here factually, he can?
No,
But
well,
if he's challenging it facially, he can't?
so the cases he relies on is a lot to do with, like, for example, the Equitable Life case. In that case, there was an administrative agency that had an administrative law judge that's always appointed to serve in that role. And in this case, not only are there no constitutional rights to a liquor license, which means that there should be no facial challenges to the actual alcoholic beverages and cannabis articles that should be brought to the liquor board, but this also comports with the law that actually allows for a majority of the Baltimore City commissioners not to even be attorneys at all. It just requires one member to be an attorney, and there's just no legal basis for a non-legal majority to be able to have the authority to rule on facial challenges to the constitutionality of state legislation.
Of course, two of us are lawyers.
In this case, but the fact is that the composition of the liquor board by law is allowed to be a majority non-legal. And so the local board has the authority to apply the law under the articles for alcoholic beverages to specific cases, but it does not have the authority to rule on facial challenges to constitutionality.
Okay. Anything further?
Not on that matter, but substantively, I did want to address what Mr. Priebus has brought up. I did mention that there's no constitutional right to a liquor license, and that really stems from the 21st Amendment. And that gives very broad authority to each state over alcoholic sales and over liquor licensing. The Maryland legislature clearly sets forth in Alcoholic Beverages and Cannabis Article 4.2.12, a license issued by a local licensing board is not property and does not confer property rights. And the Maryland Supreme Court has a large body of case law that says that selling liquor pursuant to a license is not a constitutional right in Maryland, but a privilege that is terminable at will. There are 3 cases that I cited, and I'll just highlight 2 of them. Abramson v. State said, a liquor license by the terms of this act is a privilege to be granted, withheld, or withdrawn on such terms and conditions as the legislature may prescribe. And Federico v. Bratton, which really is the most compelling and authoritative, this was in the highest court of Maryland. The Act of 1933 expressly provides that a liquor license is not a property right but a privilege, so that he would not be deprived of a constitutional right by the refusal of the board to, in that case, renew his liquor license. And they go on to specifically affirm that the legislature can impose restrictions and prohibitions, naming this 50% rule as a cause that a liquor license can be refused. Mr. Priebus referred to improper delegation versus merely prohibition waiver, but all of those arguments are irrelevant for a liquor license. This is premised on the fact that there might be a constitutional right, which is true for property, and all the cases that are discussed in the case law that he cites are property law, it's zoning ordinances, and other cases that have very established rights. And the only liquor license cases that Mr. Priebus relies on are Connecticut and Massachusetts, and for good reason, because Federico v. Bratton is solid in Maryland. Each state is open to interpret their own liquor license law, as each state enjoys broad authority, as we discussed, and is distinct. And Maryland's legislation is clear. Maryland's case law is very clear. Federico v. Bratton is very clear.
Okay, thank you. Did you want to have the last word, Mr. Priebus?
Thank you.
Oh, I'm sorry, I did want to mention one thing, because Mr. Priebus did mention an example of a 200-foot or 300-foot law. That's just in his own words. There was no actual support for a prohibition on a liquor license as the example that he gave. So all the prohibition language was regarding properties, as I had mentioned.
Yeah. I'm just musing about this, but it seems to me that there's a small difference between a prohibition and a criterion. You have to meet certain standards. if you can't meet them, you can't get one. If you're 200 feet from a church, you might not be able to get one. That maybe you could phrase it that one of the criteria is you can't be 200 feet from a church, you know. But anyway, let me hear from you.
Okay. One little point in Ms. Coe's presentation is, she'd indicated that this board does not have the power or the ability to determine a constitutional issue, but that these issues, the Supreme Court cases derived in the zoning context. Our zoning board does not require the members to be lawyers either, so.
But it is true that there is such, with property, you can have a Fifth Amendment taking without due process, which is not something that would apply here, right?
Correct.
Yeah.
Okay, so going back to Moose Lodge versus Irvis, 92 S. Court, 1965, decided by Justice Rehnquist, June 12, 1972, a situation where a Pennsylvania state senator was invited to an event at a Moose Lodge in Pennsylvania and was denied service because he was an African American. The Pennsylvania Liquor Board revoked their liquor license. The case went all the way to the Supreme Court, and the court indicated that in order to invoke equal protection law, that had to be state action. And they made a distinction as to when does the state get sufficiently involved for the enforcement of these not only discriminatory but disgusting rules and still allow somebody to have a liquor license. And the court in 1972 said that there was not sufficient state action. That was easily remedied if you read your history. They went back the next year and the laws were amended and indicated that no licensee could discriminate based on race, color, religion, what have you. And the Moose Lodges, for the most part, complied. Some of them, I believe, in Hagerstown, closed down. But that's all history. For the purpose of my bringing this up, the issue is not so much of whether this is a property right, but where you have a governmental body that is applying law. If we were to agree with Ms. Coe and say, it's not a property right, therefore, you can deny somebody a liquor license because you don't like the way they look, or because of their race, or in today, Holocaust Remembrance Day, because they are Jewish. This board is not going to be involved in that.
I mean, if a statute were based on arbitrary and capricious criteria, you could challenge it on that basis, right?
Yes. But what you have by delegating to private individuals, they have no constraints. They didn't raise their right hand and get sworn in to be members of this board.
I understand your argument.
So that's where I'm going with that is, yes, a liquor license, well, this is a digression. A liquor license is a property right if it's between a secured party or between a buyer and a seller, and that's the Rosedale Associates Limited Partnership versus Left Dot Inc., but is not a property right as between the licensee and the board, and is not a property right in Prince George's County for whatever reason, what they do over there. Okay, so it's not, but then if you have a system where we're administering something that's not a property right, it's a privilege, but we can decide, well, you don't get a driver's license because of whatever, and you do, it's just, or then you have sufficient state action that now you have a system that throws things into an arbitrary and capricious system that denies both substantive and procedural due process. And there, I just can't imagine a system in our government that would allow such a thing. And by delegating, that's what you're doing, because the neighbors, they don't have to say, or they could get up here and say, we're denying Mr. Lang because he's black, and there's nothing you can do about it. So this law's got to go.
Okay.
Thank you.
I have an answer to that. So just very briefly, Mr. Brevis brought up Moose Lodge and v. Irvis. That's obviously, we haven't had a chance to look into it, but it's Pennsylvania, as he mentioned. It's regarding an established right against racial discrimination. All of that is not relevant in this case. And he mentions the arbitrary nature of this legislation, but that's actually not true because, first of all, facial challenges to constitutionality, the Supreme Court has established has an extremely high burden, and Washington v. Glucksberry has said, and U.S. v. Salerno has said that a facial challenge must fail where the statute has a plainly legitimate sweep. And 121508 directly speaks to the actual prerequisites that the legislature wants of public need and desire for this license in section 4210. They have a clear weighing of the interests of the applicant's desire against, the impact on the general health, safety, and welfare of the community, including issues related to crime, traffic conditions, parking, or convenience, and who but those who are living closest to the establishment where it will come would be the most affected. And so there is a plainly legitimate sweep here. It's not arbitrary. I don't think there's any question of fair administration of these rules. Proper notice and such was given. And on top of all of that, there just is no vested right in a privilege that's not even granted yet. We're talking about applying for a liquor license. So there's just no reliance whatsoever as well.
Okay. All right. Counsel, thank you. I read the memoranda. I thought they both were very well done. I think the arguments are interesting. I would vote to deny the motion to dismiss for a couple of reasons. One, I'm not convinced that this is a cognizable constitutional right that's being denied by the statute. I also think the statute sets up what may well be reasonable bases for prohibiting it, in that it's limited to the proximate location, the residents who are within a certain distance from the proposed location. I don't think it's arbitrary or capricious, but you may be able to convince the court that it is, and good luck with that. I don't know where the court would go, but for today's purposes, I'd vote to deny the motion to dismiss and ask my fellow commissioners what their view is.
Okay, based on material and testimony provided today, I vote to dismiss.
The motion was to dismiss. I'm denying it.
Okay, to deny to dismiss. Okay.
Yeah, it's fine.
Yes. I read the motion to dismiss. You guys make great arguments. I have my own thoughts on that. I'm going to defer to the chairman. I do agree with the chairman's decision today on his vote to deny the motion to dismiss. I'm going to do the same thing.
So let's proceed to determine if you've met the threshold, Ms. Coe. So I don't know if you have anything preliminarily or you want to call a witness.
So I've obviously never done this before. It's invoked so rarely. I guess I will present the number. And we weren't given an exact tally of the whole universe of properties, but from the spreadsheet, I saw 65 properties listed.
I believe it was 64 or something.
Okay, 64. 64 property owners were listed, that's true. So we would need more than 32. And by my count, I have 38. I don't know if the board was able to make their count or how the determinations usually work.
Well, I believe that there's someone here from the planning department. You were sworn, sir?
I was.
And can you come up and state your name for the record, please?
My name's Nicholas O'Gara. I'm a GIS analyst with the planning department. O''G-A-R-A.
So were these affidavits submitted to you?
No.
What did you do?
Our department does the analysis that identifies the 200-foot area around the property lot. So what we did was to identify those properties and then deliver them to the board.
Okay. Do you have any questions for, is it O'Gara?
That's right.
Do you have any questions for Mr. O'Gara?
No, I don't.
Do you have any questions for Mr. O'Gara?
I don't challenge the universal votes at 65. 65 you had?
64.
64.
I didn't count them, but do you know?
I don't, actually.
Well, if we get that close, we'll have to count them, but, okay.
Well, let me ask you, this is what I was provided with, and I counted every piece of property that touched in this Pimlico racetrack-looking design as 65.
Maybe it is 65, I don't know.
This list was given as well. This was in the materials that were given when we all received the packet. And if you look at the property owners, or the property addresses, I counted 64 property addresses.
I mean, did you count them that recently to see whether it's 64 or 65? Or do you want to take a minute and do that?
Yeah, please, if I can.
Mr. Chairman, if I might, and for the record, sir, my name is Michelle Wurzberger. I'm the Deputy Executive Secretary for the agency. The reason that it is 64, there are 65 properties that are in that universe. However, we are only considering 64 because the law provides that you do not count the property in which the license is being applied.
So 4001 Falls Road drops out, and then there's 64?
That is correct, sir.
Does that answer your question?
It does. I raise a question because there is a liquor store, a liquor license establishment in that property. It's not, it doesn't comprise the entire property, so
Let's see how close we
disagree.
get. I don't know about I don't know if we have proof of that either. So, okay, so that's all you did.
Correct.
Thank you, you're excused.
Thanks.
The next step then was to determine whether we had received affidavits from more than half of the people who live there, right?
I disagree. The statute requires that the people come and vote in person. The statute exempts, if there is more than one owner of the property, that the other owners can vote by affidavit. But the actual protestants have to appear in person. And that view is supported by the case of Patton versus Liquor Board. Excuse me 1 second. Quoting from Patton, 667 Atlantic 2nd, 940. This would be 943. The third property is located at 838 South Bond Street. This property, co-owned by Dorothy Pabst, Reverend Louis Pabst, Audrey Polton, and Louis Polton, was awarded a one-vote protest. Dorothy Pabst went to the board's hearing and voted in person against the transfer application. Reverend Louis Pabst and Audrey Polton filed their protest by affidavit. Louis Polton was unable to vote because he was in intensive care at a local hospital. The court went on to determine that because they had one vote and two affidavits, which is 3 out of 4 people, did not require the vote of the fourth person, and the majority rules in a joint ownership situation. But it clearly spelled out that they are supporting the view in 12-1509 that somebody has to come vote this property.
Can you
in
read me the
person.
statute? You have the statute in front of you?
Yes, sir.
Okay, so this is 12-1509, B, I guess. If an owner of property that is owned jointly appears in person, the other may be recorded by an affidavit. But it doesn't say anything about you're saying that, that implicitly requires others who are the sole owners to appear in person?
Oh, absolutely.
And what's your position, Ms. Coe?
Well, looking at 121508, the only mention of anything in person is if a property is rented jointly and one tenant appears in person at the hearing as a protestant, the other tenant's protest may be recorded by affidavit. So there's no actual language in the statute that requires in-person participation. I feel that the Liquor Board has established a proper procedure for ensuring participation, and we were given that information and we followed it.
Okay. You were sworn?
Yes, sir, I was.
Okay. So what is our rule about this? What, our protocol?
Our protocol, which the board approved a couple of months ago, which we've now had a couple of protests under, is that once the community or someone indicates that they want to pursue this, they have to submit an email indicating such. The transfer hearing would be pulled. We will provide, we will then get from Planning Department a map that shows all of the properties within 200 feet, as well as a listing of all of those properties and their legal owners. And then we send those documents to both parties, along with affidavits that have been prepared for tenants, for property owners, and for corporate owners of properties. And that is what we did.
Okay.
It was my understanding that the purpose of the board's rule, because that's a new rule, that wasn't the way it applied back in 1995 when Patton occurred, was for the community or the neighbors to make a prima facie showing, and that this board wouldn't put in a hearing for a 51% protest unless and until a sufficient number of affidavits were provided for the purpose of generating that hearing. But it didn't take away, you can't, okay. But the statute still requires that people protest in person.
Only impliedly, not expressly. It doesn't say it anywhere.
I mean, you read that section out of the law if you interpret it otherwise.
Well, the nature of case law, too, is that they're affirming what was decided in the Liquor Board hearing below. I don't think they're affirmatively ruling or holding that in-person is required. And again, I don't have access to your case law, but.
Well, I'm not prepared to say that they have to be here. I think that, we could have a situation with 1,000 people in proximity, and the board would have to hear from 500 people. I don't think that's required under the statute, but maybe you can convince the court that it is. Since it seems like you may be going to a court anyway on my prior ruling, you can raise that as well. But let's go to the next step. So, assuming we have identified 64 owners, residents, or others in the 200-foot proximity, what's next?
Again, I count 38 of those 64 properties as being in the packet of affidavits that were signed and submitted and given to all the parties.
And you received those?
I received them. I disagree that each one gets a vote because the statute lays out that if there is a residential property and that residential tenant has lived there for at least a year, that the tenant gets a half vote and the owner gets the other half vote. So you've got several half votes in your count.
So have you calculated that?
I'm not sure because I wanted to question people to find out who was living where when.
No, in the affidavits,
One of-
it's clear. I'm sorry. Go ahead.
I'm sorry. One of the affidavits was from somebody that I know that I don't think they live in the States. I was expecting to be able to question them.
But you didn't notify anybody that you wanted them here?
Oh, absolutely not.
Okay.
I was
It's
just
their burden.
I was just going to say that the affidavits were very clear as to who were tenants and who were owners. Each affidavit was different if it was a business versus if it was a tenant versus if it was an owner. So, I mean, you could have easily looked through to see who were tenants or
All right,
owners.
so let's cut through this. So did you review them all?
Yes, sir, I did.
What did you determine?
So I determined that there were, let me just say preliminarily, there was one affidavit that we excluded immediately because it wasn't legally sufficient. The notary hadn't put who had come before him, so we didn't even include that in the packet, frankly. But we received 38 total affidavits, 34 were owner affidavits, and 4 were tenant affidavits. It is, through my analysis, suggests that that they all, other than the one that is not counted in that number, were sufficient. And I can go through which properties we received affidavits for and who signed it, if you would like, Mr. Chair.
No, it's not up to me. So, do you want to question her?
Sure. Before I do that, let me raise this, and then I'll rephrase it as a question, Ms. Wurzberger. The one issue I had is an individual owned 2 separate properties. Mr. Amir, who was involved in the negotiations, did you count him as 2 votes or 1 vote?
I counted him for a vote for each property, but I did not count it was one of his tenants who submitted the affidavit that we dismissed.
Okay, so he's now, you allowed 2 votes for each property, and I'm not taking issue with the entity. He owns an entity that owned a 3rd property, and I believe an entity and an individual
Correct.
be counted separately. But it's my argument that he should be counted as 1 vote, and you indicated that his tenant's affidavit was
Dismissed. And actually, that was for the LLC. My apologies.
okay.
But yes, he owns 2 properties, and each property gets 1 vote, so we counted 1 vote per property.
Okay, so if you had 64, universe of 64, then the protestants need something more than 32.
Yes, so we rounded up and said 33 votes, because we didn't have any half
You
votes.
could have had half, right.
Yeah, but we didn't.
32 and a half would
So
have-
we rounded up.
Right, I understand. Okay, so you had 38 affidavits,
Correct,
4 of which were tenants.
correct.
So you're saying that you have 34 whole votes, and then you have 4 half votes.
Well, you only have a half vote if you have 2 people voting. That's how I read it. And if it's only the tenant voting, then they get a full vote.
Okay, I respectfully disagree, but I understand how you did that. Okay, so is there a process in place for the liquor board for non-protesting affidavits? The board only submits protesting affidavits.
I'm sorry, I don't understand your question.
Okay, so the board has determined that the new rule provides for a fair procedure where people can vote by affidavit and not by appearing in person. So if a tenant votes by affidavit, then the landlord would not be afforded an opportunity to vote by affidavit, to say, I want this property.
So to be clear, we did not mail these to anyone. These were provided to both parties. And certainly your client or you could go to all of those properties or mail adjusted affidavits and have people, vote one way or the other. That said, we did not have any situations where we had property owners who were in disagreement, either with each other, if they were two or more people who own properties, or in a disagreement with their tenant. We did not have any situations like that. And there have been many situations, and you and I have been on these same positions years prior, where the applicant went and got petitions suggesting that folks supported them and were not in opposition. And certainly, you all could have taken the list that we provided, which gave not only the address of the property in the footprint, but also their mailing address, and reached out to them. And we would have accepted anything.
Okay.
But we didn't receive anything.
All right. So I want to note for the record that I believe the applicant has been prejudiced by proceeding here today by allowing affidavits and not requiring that people appear in person, other than the carve-out in the statute that allows joint owners.
Okay.
So, Ms. Wurzburger, so you're counting 38 votes out of a possible 64?
That is correct, sir.
Okay, just so I understand.
Any other questions for her?
No further questions.
That would meet the threshold. Do you have any evidence that you want to present?
As
mean,
to the
38
issue of the
is-
51% rule.
Yes.
No,
I mean,
I just-
38 is more than half.
Okay, I would like to argue, not that it gets me to 32, but that Amir's vote only be counted as one, in that he owns two properties in his individual name.
Yeah, I don't know the answer to that question because the statute's silent on it. It
Yeah,
talks
there-
about owners.
There is a provision that says if a property's owned by the state or by the city, and there are more than one property, that they only get one vote.
But it is-
When we had the
it's-
Callie's Court case, we actually had that situation where,
Mr. Chair, just for the record, if you so wanted to do that, you could strike one of Amir's, just to be on the safe side.
I think it's a moot question really here in this context because it doesn't get you where you want to go. So I don't want to, I think it's an unnecessary ruling. The statute's silent on it. It may be one vote, it may be two, but in either case, they've met their threshold. That deprives us of the authority to grant the license. So unless there's something further, I think your next step is up the street. Okay.
absolutely up the street.
All right, so having found that the opponents met the threshold of the statute of Section 12-1508 because they were within, owners or residents within 200 feet of the proposed license location and opposed to it, I find that deprives the board of the authority to grant the license under those circumstances. And having denied the motion to dismiss, that would conclude the case. Commissioners agree?
Great.
I agree, yes.
Any exhibits for the record, Ms. Russell?
Yes. Medical exhibits for the record, Board Exhibit Number 1, 11 letters of opposition from community. Exhibit Number 2, Community Law Center, hearing outline.
Okay, thank you, folks, and thank you for the presentations. They were interesting.
Thank you.
Okay, good luck.
I had a quick procedural
There
question.
being no further business before this board, the board is in recess until Thursday, May 8th, 2025 at 10:30 a.m., when again, the board will hold its very first hearing in the new hearing room located at 200 St. Paul Place, Suite 2300. We are adjourned, sir.
Did you have a question?
Yeah, very quick question, whether in the record, the motion to dismiss and the brief in opposition are actually in the file, because I didn't happen to see it yesterday.
They will,
They
I
will.
mean, I would rule that they're part of the record in the
Okay.
case, and they'll be received, okay?
Okay, thank you.
Bye.
Thank you.
Thank you.